Welcome to our California Real Estate Exam Prep video series. We'll give you 20 daily practice questions for the next 100 days with detailed answers to help you pass the exam and get your license. If you like our videos, please like and subscribe. Let's start now. 1. Concerning construction loans, most lenders will disburse the last and final payment when the A. Notice of completion has been filed. B. The building has been completed. C. The period to file a lien has expired. D. The buyer approves the construction. Answer: C. Most lenders will make the final disbursal of a construction loan after the period to file liens, such as mechanics liens, has expired. 2. An architect often draws a plot plan for the purpose of A. Showing the details of the foundation construction. B. Guiding building construction. C. Showing exterior sides of the houses. D. Guiding placement of construction and related land improvements. Answer: D. 3. Occasionally, the title to real property becomes unmarketable. Which of the following causes would be least likely to result in that eventuality? A. Imperfect title, due to a breach caused by adverse possession of a prior owner. B. A lease pendens filed by the husband of the owner of record. C. Restrictions imposed by a private owner through a deed notation. D. Public restrictions contained in zoning ordinances and building codes. Answer: D. Public restrictions rarely cause title to real property to be unmarketable, private restrictions sometimes do. 4. According to the regulations of the state housing law, one seeking the issuance of a building permit should make application to A. The local building department. B. The Department of Urban Renewal. C. The Department of Housing and Community Development. D. The Bureau of Real Estate. Answer: A. 5. If an owner wanted to sell his property, extending credit himself, and retain the legal title, the instrument used would be A. A security agreement. B. A mortgage. C. Aerial property installment/conditional sales contract. D. A bailment. Answer: C. This is another name for a land contract, and under a land contract, the seller of the property retains the title and provides the credit to the buyer, giving the buyer the use and possession of the property and equitable title. 6. Both buyer and seller have signed a real property conditional sales contract, the effect of which would be A. All right and interest of the seller now passes to the buyer. B. An equitable title passes to the buyer. C. The legal title passes to the buyer. D. No title to the real estate passes. Answer: B. When a buyer and seller have signed a conditional sales contract, land contract, the buyer receives equitable title to the property, and the seller retains the legal title until such time as the contractual obligations have been fulfilled by all parties. 7. An acknowledgment may be taken by a notary public who is a. The grantee in a deed which is being acknowledged. B. The mortgagee in a mortgage being acknowledged. C. An employee of a corporation who has executed an instrument being acknowledged, if he is not personally interested. D. The grantor in a deed being acknowledged. Answer: C. The notary public who takes the acknowledgement cannot be an interested person in the transaction. The grantee and the grantor in a deed would be interested parties, and the mortgagee in a mortgage would be an interested party. 8. When comparing a straight note with an installment note, the straight note A. will have equal annual principal reduction payments. B. will have no principal payments during the term of the loan except on the last payment. C. will have a total effective interest rate greater than if the loan were an installment loan. D. None of the above. Answer: B. A straight note is a promissory note in which there are no payments on the principal until the end of the loan. There may be payments on the interest during the term of the loan, or the interest may be paid at the same time the principal is at the end of the loan. The rate of interest will not necessarily be greater. 9. A construction lender wants to make sure that his loan is adequately secured as a primary lien. When a loan for the purchase of the land is already an encumbrance against it, a construction lender would be least protected by which of the following? A. Ordering an ALTA policy of title insurance. B. Recording, publishing and posting a notice of non-responsibility. C. Recording a subordination agreement from the purchase money lender. D. Making a physical inspection of the property. Answer: B. A notice of non-responsibility is used in a mechanic's lien where improvements have been ordered by someone other than the owner. It would not protect a lender. 10. A buyer relied upon the fraudulent statement of the seller's agent and was damaged. The seller was unaware of the agent's false statement, and he tried to enforce the agreement. The buyer A. could sue the seller for fraud. B. could sue the seller's agent for fraud. C. would have sufficient grounds for rescission. D. could do any of the above. Answer: D. If the buyer were damaged because he relied upon the fraudulent statement of the seller's agent, he would have sufficient grounds for rescission and could not sue both the seller and the agent. The seller would be liable for the acts of his agent under the law of agency. 11. Concerning options, which of the following is the most correct statement? A. An option may be resold by the optioner at any time before the optionee exercises the right to purchase. B. If a lease contains an option to purchase, this right ordinarily will pass with an assignment of the lease, even though such option is not specifically mentioned in the assignment of the lease. C. An option as a contract is distinguished from other contracts in that an option must have mutuality of rights and obligations. D. An option contract creates a fiduciary relationship between the optioner and the optionee very similar to the fiduciary relationship between a broker and principal. Answer: B. If a lease contains an option to purchase, this right ordinarily will pass with an assignment of the lease, even though the option may not be specifically mentioned in the assignment of the lease. An assignment of a lease is defined as transfer of all rights in time, interest, space, and rights. Broker Hayes took a 90-day exclusive agency listing to sell a property that was owned by Wilson. After 30 days, Hayes had not sold the property, so Wilson sent him a certified mail letter canceling the listing. 1 week later, Wilson listed the property with several brokers using open listings. 2 weeks later, one of the brokers who had an open listing on the property completed a sale to new owners. In this situation, Wilson most likely A. Did not have the right to give open listings to the other broker. B. Had a right to relist the property and also the right to cancel Hayes' listing, and his notice of cancellation would accomplish this without possible liability to Wilson. C. Owes the commission only to the selling broker. D. Is liable for payment of commission to Hayes as well as to the selling broker. Answer: D. The owner has the right to cancel the exclusive agency listing before it terminates, but if he does, he is liable for any damages suffered by broker Hayes, the listing broker. Inasmuch as the property was sold within the 90-day period, the owner is liable for damages, which would be a full commission. 13. A federal RESPA booklet and disclosures must be given to a borrower by a real estate licensee when the federally related loan is a first lien and the money is used to A. Purchase 30 or more acres of farmland. B. Build 5 or more residential units. C. Purchase 1 to 4 residential units. D. Add a room on to the borrower's residence. Answer: C. RESPA applies to the purchase of 1 to 4 residential units. 14. Which of the following closing costs would be classified as a recurring cost? A. Recording fees. B. Title insurance premiums. C. Escrow fees. D. Impound account items. Answer: D. Of the costs listed, impound account items are normally paid with the monthly payment of principal and interest, and thus reoccur throughout the loan. The other items normally are paid once, at the closing of the escrow. 15. A real estate licensee has a practice that when he is approached by members of minority groups who want to be shown property, he avoids showing them property in integrated areas. This would be an example of A. Redlining. B. Blockbusting. C. Steering. D. Proper conduct. Answer: C. Steering is guiding customers to certain areas based on their race, etc. 16. Mr. Jones, in order to comply with the regulations of the state housing law, should seek the issuance of a building permit from A. The local building department. B. The nearest office of the Department of Housing and Community Development. C. The California Department of Real Estate. D. The California Department of Urban Renewal. Answer: A. The state housing law sets minimum standards. However, all building permits are issued from the local building department, be it city or county. 17. Agent flag often refers to tax shelters when discussing a property with a customer. Agent flag is primarily referring to A. Real property taxes. B. Mortgage relief. C. Interest income. D. Income taxes. Answer: D. The term tax shelter is used primarily in referring to being able to reduce an individual's income tax liability. (18) In attempting to determine the liquidity of a business venture, which of the following ratios would give the most accurate information? A. Fixed assets to fixed liabilities. B. Total capital to total liabilities. C. Current income to current net worth. D. Current assets to current liabilities. Answer: D. The liquidity of a business is its cash position, hence, current assets to current liabilities. (19) The greatest possible income which a given property is capable of producing in terms of operating income is termed A. Gross scheduled income. B. Gross effective income. C. Net operating income. D. Net spendable income. Answer: A. 20. Trustor is to beneficiary as A. Alienate is to convey. B. Attorney in fact is to agent. C. Mortgager is to mortgagee. D. Vendor is to vendee. Answer: C. The trustor is the borrower under a deed of trust, the beneficiary is the lender. The mortgager is a borrower under a mortgage, the mortgagee is the lender. Thank you for watching. I hope you found this video helpful. If you did, please consider subscribing to our channel so you don't miss out on our future videos. We look forward to seeing you in the next one.